On here. So we've got a few matters on calendar today, and as I always say when I preside, when you appear before the Ninth Circuit, there are no bonus points or extra credit for using all of your time. So if you've made your points and you're not getting any questions back, it's okay to sit down. And with that, Mr. Gunn, good to see you. We'll call the first matter, United States versus Godwin.
Morning, Your Honor. As you just recognized, I'm Carl Gunn. I represent Mr. Godwin. Your Honors, what happened here, an in absentia proceeding, goes against one of the most fundamental premises of our criminal justice system. I don't know about Your Honors, but it's something I haven't ever seen in more than 40 years of practice in federal appellate and district courts. And that includes 28 years as a federal public defender where I saw lots of cases.
So let me ask you about that. I take your point. It's unusual. What would you have had him do here? Just continue to give, obviously in hindsight, you could say, well, just give one more extension.
Right.
But we didn't, he didn't know that at the time. But is that what you would have him do in this situation?
Your Honor, what I would have him do is simply vacate. This is a case where warrant got arrested, so everyone knew several months ahead of time the defendant was out there somewhere and probably not going to come to court. What I think the judge should have done is vacate the sentencing date and then reset it once Mr. Godwin was arrested. If he wanted to have a date on calendar, he could have.
The arrest warrant had already been out for 3 months at this point, right?
Right.
So, you have to look at that in context. What if he'd been on the run for another 3 months?
He could have set a status conference left the matter on as a status conference. Obviously, if it's, it's probably he might have wanted the prosecutor to check with the marshals and bring in a report every couple of months.
I had a question about that. This really all happened only in a matter of hours after the close of that hearing. Is there any information in the record about when the government knew where he was?
You have two competing premises, and that goes to my second issue, Your Honor, of there being error and not at least holding a hearing. The defense attorney filed a motion as soon as he found out Mr. Godwin was in custody, which was the day after. And what he said in his motion was it's unclear whether he was in custody at the time of the sentencing at the very hour.
My question is actually even before being in custody, because in order to arrest him, someone had to know where he was. And so to me, the question is, when did they know where he was, which could have preceded the arrest by a day or an hour or a minute?
All there is in the record, Your Honor, is what I just described sentencing counsel or defense counsel indicating, which didn't include any information about that. The prosecutor in response claimed that the police had run across him in a stop around 5 p.m. and arrested him when he ran about a half hour after he ran. The problem is you have two competing sort of possibilities there, and that's why it was at the very least important to hold a hearing under that Brewer case. I'm sorry.
I'd like to drill down on that because I'm not aware. The only thing I saw was the 515 statement, which has its own problems because it wasn't from the police officer. There wasn't a police report attached. But what are you relying on to say that he was actually, you said that the defense counsel said that he was in custody before the hearing ended at 2:56 p.m.?
No, that it might have been, that it was possible. It's an excerpts of record in the motion, Your Honor.
I guess my question is, okay, well, go ahead, give that to us first.
It's an excerpts of record 32. The defense motion says, quote, it appears quite possible that he may have been unable to attend his sentencing.
I guess I'm wondering why that even creates a factual dispute. That really accounts to almost nothing. It's possible. Well, there's no basis, there's no factual statement, there's no suggestion. The only facts we have, which are not solid, but is that at 5:15 they located him.
Well, it seems to me that you have to have a hearing to figure out what those facts are rather than just take a double or triple hearsay from the government in a opposition it filed on 2 hours' notice or whatever.
There was no sworn evidence of any kind about the timing. Is that right?
No, all there was, the government's, the motion I just read is 2 pages, at excerpt of record 3132, and the government's response is at excerpts of record 2930. And I think it basically says what I just described. But, I mean, that, of course, begs the question of what standard should have been applied at the initial finding. The sort of, obviously, we've got the Ornelas case and the Hutchins case. Hutchins held all you need is a finding of voluntary absence, and after that, the district judge is basically free to do whatever he or she wants. Hutchins should not be extended to the sentencing context for a couple of reasons. First of all, it creates a split in the circuits already in the trial context, and there's no reason to aggravate that by creating the same split in the sentencing context. Second, trial is very different than sentencing. You have constitutional and statutory speedy trial rights at trial that you don't have at sentencing. By the way, I'm going to try to save 2 minutes for rebuttal if I can. You have a bunch of other participants who are inconvenienced, not just the attorneys and judges. You have the defendant is probably much more important at sentencing than at trial, where most of the time the defendant doesn't even testify, and when he does, he's only one of a number of non-attorney witnesses speaking. So you shouldn't extend the sentencing context, and Ornelas did not do that. I've gone back and read Ornelas very carefully, and you can also go back and read the briefs. Not only did Ornelas not decide the question of whether there should be a balancing test after the finding of voluntary absence, but it wasn't argued in the briefs. Ornelas decided 2 things. It decided what the standard of review should be for what the district court did, which in that case was make a finding of voluntary absence. It said that should be an abuse of discretion review. And then it said, we're not going to adopt this enhanced standard that the Seventh Circuit did. That's all Ornelas decided. Ornelas did not address whether Hutchins' rejection of the balancing test should be extended to sentencing. So Ornelas, the question's open before this court, and especially in the sentencing context, where in most cases the inconvenience is going to be relatively low, you should at least have a balancing test. Well, the only harm here, maybe in the sentencing context, is people spend time preparing that they didn't have to prepare. But that wasn't true here because the court could have vacated the sentencing date. Then you wouldn't even spend that time preparing. So there's just absolutely no reason, and in hindsight, lots of no reason, given that Mr. Godwin was quickly arrested.
And the hindsight becomes a little bit more problematic because he actually moved to reopen, or asked for, what was it, a motion after he was kept. Didn't the defense counsel file a motion to come back in for resentencing?
Right, he did. But I mean, I'm not relying on the hindsight, but just the hindsight illustrates.
No, I'm actually saying hindsight becomes it helps you because there was a motion there. One more question, just to be clear, this is not a claim that the sentence itself was unconstitutional, but that there may have been some constitutional infirmities in the process. Is that correct?
Yes, I mean, very, very fundamental.
So let me follow up on that question because there was an appellate waiver in this case.
Correct.
And so one of the questions is that, does that appellate waiver cover this? And there's a case before our court right now that's gone in bank that may answer that question.
The Atherton case, I think you're referring to.
Right. So I'm going to give you a little more time, so don't worry, you can keep going.
Right.
But what do we do in that situation? If Atherton comes out the way the government wants it, does any of this ultimately matter?
I think it does because the procedural issue here is, I think, is different and more central than the procedural issue in Atherton. As I recall, and I haven't read Atherton carefully because it wasn't cited or brought up in any of the briefing.
It's going to be, it's
Right.
gone.
But as I recall, the issue there was sort of the impropriety in the way evidence was considered or something like this. Here we're dealing with something more fundamental. We're dealing with proceeding without the most important party even there. So I think that's different than what's going to be presented in Atherton.
I have one final question for you, and we will give you the 2 minutes for rebuttal.
All right.
This issue was not briefed, but this case involved a certain district court judge who has since resigned.
Yes.
And I know there have been some having to redo stuff. I didn't see anything about that in this case. So I'll ask the prosecution the same question. Is this one of the cases that is being looked at to be redone because of who the district court judge was?
If you go back to the record in this case, Your Honor, you'll see that we stayed it for about 6 months to have that investigated. And there was, district court counsel was appointed for that, and then we decided to go forward with the appeal. So there's nothing pending right now. I certainly don't want to suggest that there might not be something discovered later. But that is certainly an underlying troubling aspect of the case whenever you have a Judge Kindred case, I guess. But
Very well. Okay, we'll go ahead and give you 2 minutes for rebuttal.
thank you, Your Honor.
Thank you, counsel.
Thank you. May it please the court, Amy Miller on behalf of the United States. This court should enforce Godwin's valid appellate waiver and dismiss this appeal. From the government's perspective, this case should back up, and this court should look at specifically the appellate waiver in this case. Mr. Godwin knowingly and voluntarily entered into the plea agreement, and as well as had a knowing and voluntary waiver of his appellate rights.
Except that, counsel, he waived the right to appeal on all the grounds contained in Section 3742, which does not, none of the sections mentioned in the plea agreement either contains constitutional claims or the procedure by which the sentencing occurs. So why should we read those extra things into the plea waiver?
The plea waiver would have encompassed those 2 points. This plea waiver specifically phrased that if the district court sentenced not beyond the statutory max, then the defendant would waive all appellate rights, specifically under 3742, which would have included an illegal sentence, a sentence imposed as a result of an incorrect application of the guideline range, or if the sentence imposed was greater than the sentence in the bill.
That's exactly my point. None of those has anything to do with the procedure by which he was sentenced. They are substantive, and the right of allocution can result in a different sentence. Just, that is one of the reasons why it exists. So I still don't understand why you think that those references to 3742 waive the right to challenge the fundamental procedure by which the sentencing occurred.
And this court has already alluded to in the questions to counsel that that question of the extent of the appellate waiver when it comes to constitutional claims is being considered by this court en banc, I believe, next month. So, but here, this appellate waiver did include illegal sentences, and this court in Bibler has stated that an illegal sentence is one that exceeds the permissible statutory penalty or violates the Constitution. So here...
That's again about the substantive sentence. Let me ask you a different question. At the hearing, counsel said that, among other things, that he wasn't sure whether the defendant knew of the recently changed date of the sentencing, and the court didn't believe the lawyer. What do we make of that in terms of voluntariness?
So in the Hutchins case, this court addressed, in the trial context, the question of when the defendant may not have had notice of a specific date of the hearing. In that case, the trial was set twice. The defendant knew of those specific dates, and then it was continued from there. And the court ultimately said that it's rewarding his own lack of staying in contact with his attorney or knowing of the date, and found that there was no issue on that specific point of not knowing the date. Here we back up. The defense counsel admitted to the court the last contact that he had with Mr. Godwin was the change of plea. At that hearing, the magistrate judge specifically ordered him to be present at the sentencing date on September 6th at 11 a.m. Mr. Godwin himself clarified the time, asked the court the date and the time again. It was said about 3 times throughout that hearing. And he was not present based on the record, the limited record we have. There's no indication that he was present on September 6th, and can acknowledge that that date was moved to the 7th and then to the 12th. But if you back up before that, the arrest warrant issued in June.
But the fact that he didn't show up at something that didn't happen doesn't really tell us whether his not showing up to the second continued date was or was not voluntary. I think what bothered me the most about it was the judge simply saying that he didn't believe the lawyer who said, I could make indirect contact with him and I'm not sure he knows of this date.
But isn't your point that that doesn't really matter because the case law suggests that if he's withholding contact from his lawyer, then whether he knew about it is irrelevant. I mean, maybe that doesn't address, maybe that means that the district court decided it on, or, gave the wrong reason because the district court said, I didn't believe you. He didn't say it's irrelevant, it doesn't matter.
And I apologize, Your Honor, the specific reference of the district court, I will admit I'm not familiar with that specific point in the record, but in the record, the court did address that he had not been in contact. And yes, to your question, that specific point would not necessarily be the deciding factor in...
Although that's not what the judge said. The judge said, I don't believe you.
And
does that matter?
I would say no, Your Honor, that here, when you look at all of the information that the court had, that Mr. Godwin, at the plea, knew that if there was that the sentencing date was not going to be continued, that he could not ask for a continuance, and that if he had any sort of violation, he would be remanded immediately. And then we have the incident in June where he is at the airport trying to leave state with a female, with over $20,000 hidden in her clothing. And he lied about saying that his probation officer had given him permission to go shopping in Seattle. And then you have an extensive period with no contact. And his attorney represented to the court, I have been in contact with people who I believe have been in contact with Mr. Godwin. The court had all of that information and ultimately stated that for the objections that the defense was putting forth to the PSR, that Mr. Godwin's presence would not have made a difference to the court ultimately in whether or not those objections were sustained, that he ultimately was not going to give him the benefit of acceptance of responsibility, and he was adding the additional points for obstruction of justice based on the violations and the conduct up until that point.
Counsel, can we decide this case before Atherton? And the reason I ask that is because I think under our current precedent, I mean, I guess you have an argument that even under our current precedent, there's still a waiver. But if we can't just assume jurisdiction, right? If we think that there might not be a waiver here and that Atherton may weigh on that, can we just assume that there was no waiver? Or is that we dismiss it. Is it a jurisdiction? It's a jurisdictional issue, but it's not a subject matter jurisdiction, I don't think.
So would say that Atherton could inform this court's decision on this specific appellate issue. And I guess going back to Your Honor's initial point or question about procedural constitutional challenge versus a challenge to the sentence, the Wells case specifically addresses that some of that point, which I know that is in question, I guess, as part of the Atherton decision, but that Wells stated that the appellate or waiver exception for constitutional challenges applies to the substance of the sentence and not the process by which the sentence was imposed. And here, as counsel agreed on your questions, that this is going to the process with which the sentence was imposed. And so ultimately, if the appellate waiver in this context and in this specific case, I think the court could consider that, even maybe separately from Atherton, but it could inform the court's decision.
So your point is, we could say there was an appellate waiver under our current precedent. Then we're subject to whatever Atherton, we're opening ourselves up to whatever Atherton does to change that law, perhaps.
Perhaps.
But my more fundamental question is, if we think that regardless of whether there was an appellate waiver, that the claims don't work here, that they're just, he doesn't have a claim, can we assume that the appellate waiver does not apply? Or or is that not a permissible route to us? And if we're going to go down that route, we should just wait for Atherton?
I would say, yeah, if you're assuming that the appellate waiver does not apply, then it would be beneficial to wait and see what the court does in Atherton. But here, because this specific appellate waiver is addressing more the defendant's constitutional challenge to the procedure, it would make sense that the court could still address it today. And I see I'm out of time, so we would ask.
Other questions? No. All right, thank you, counsel.
Thank you.
I had a copy of Atherton here, Your Honor. I looked back to refresh my memory. Atherton is really dealing on a much more sort of into the process procedural issue, if I can put it that way. It was relying on false or unreliable information during sentencing. This is a fundamental issue of whether you can go forward without the defendant even there. That's almost analogous to something like proceeding with the right to counsel versus a Fourth Amendment issue or something, I think. So however Atherton gets decided, and I guess, Your Honors, if you wanted to, could wait and see how it's written, but however Atherton gets decided, I don't think it's going to control on the sort of fundamental due process violation that we have here.
And assuming Atherton is narrow, like you're suggesting, or doesn't address this issue, then the case you'd be relying on is Ornelius?
Well, I'm not relying on Ornelius. I'm saying Ornelius doesn't reach this issue. And then I'm relying on sort of all the reasoning and
is it Brewer what's the case that would help you?
It's really the cases from all the other circuits except this circuit that even in the trial context recognize there should be a balancing even if there's voluntary absence. I did want to give a couple more points on a couple of questions Judge Graber asked. Judge Graber, you asked about this being a different date than than Mr. Godwin was told about. Not only that is, I'm not saying that Mr. Godwin was there on September 6th, but we actually don't know that he wasn't. All there is in the record is a representation by the prosecutor that she was in the courthouse and he wasn't there. But she's not saying it's not clear whether she was at the courtroom, what time she was there, et cetera. So at least on this record, we don't even know for sure that Mr. Godwin wasn't there on September 6th. I also wanted to, Judge Graber noted about Mr. Godwin's attorney indicating he'd had some sort of indirect contact through others. I think that goes, Judge Nelson, to the question you asked, sort of what reason was there to even hope he might be found? I think the fact that there was some indirect contact combined with the fact that he's a longtime Alaska resident, not a foreign citizen who you'd expect.
At least justified a hearing. That's what you're.
Well, and more than that, it justified waiting at least a few months to see if he got found or got brought in. Huh? Pardon me?
They did wait 3
months. Right. Well, I a few months more, and maybe a few months after that, depending on what things look like.
But as to your point, though, let's say we were to think on issue one, as in my mind, is did the district court abuse its discretion on that day? I think you can make a pretty good argument, no, he did not. But once it was revealed that the guy was arrested later that day, then your point is at the very minimum, have a hearing. And so we have not conferenced in this case yet, obviously, but if we were to agree with the prosecution on issue one, but agree with you on issue two, then I guess the process would be set a hearing before a new judge to determine whether it was voluntary, and if it was a voluntary absence, then maybe the case is over. But if it wasn't a voluntary absence, then it would be remanded for resentencing.
I think that's correct, but I'd like to take you back to that first issue.
I'm sure you would.
I really do think that, there's, in the sentencing context, I once had a case where a defendant absconded in the middle of the trial, and the judge did not actually proceed in absentia. He declared a mistrial. But, that's worse.
How long was he gone?
The defendant? I think she's still gone because she's from Mexico. I have stories I tell about that case, Your Honor. But the point I'm making is there, if the judge had gone forward there, I'd sort of be between a rock and a hard place complaining because you had the jury there, you had all the witnesses who had already testified. Illustrative in that case is one of the witnesses I heard later died. In the trial context, there's lots of reasons you might go forward in absentia. In the sentencing context, there really isn't. It's really the only reason to go forward in most instances is you just want to get the case off the books. Should that override the sort of fundamental need to have the person who's getting 20 years in prison be there? I'd submit no.
All right, thank you, counsel. Thanks to both of you for your briefing and your argument today. I want to commend you, Mr. Gunn, for your many years of service to the defense bar. I think I see Ms. Sun back there as well. So thank you both for your many, many years. You're clearly not doing this for the money, and you've been doing this for a long time, so we want to thank you. This matter is submitted, and we'll move on to the next case.